The Occupy Melbourne protest movement has taken its battle for the streets into the courtroom. The protesters have gone to the federal court to challenge the use of council bylaws to move them on. They're asserting they have an overriding constitutional right to protest. And as Jeff Waters reports, the case has implications for Occupy movements around Australia.
Hold that line! Hold that line!
In their efforts to occupy some of Melbourne's public spaces, this direct democracy protest movement consummately failed. To retaliate, they've taken the matter to the federal court.
This case fundamentally is about civil and political rights protected in our Constitution and the Victorian Charter of Rights, the right to peaceful political assembly and the right to freedom of expression.
The court heard today that police cooperated closely with Melbourne City Council authorities in applying local council laws to force the evictions, particularly from city parks. They were moved on for things like erecting tents and displaying placards deemed as illegal advertising. At question is whether or not these local laws can override rights said to be implied in the federal constitution.
I think it'll be good to have some information from the court on whether or not the actions were unlawful.
I think this is an important test case for civil rights, and I'd like to get that established, that we have the right to protest in Australia, and it's not at the behest of a Lord Mayor when he decides that the time is up.
That Lord Mayor wasn't entering the debate.
Well, we are before the courts at the moment and therefore I can't comment on it.
But the Premier, who's a party to the case along with the police, was defending his stance.
Everybody's got a right to protest. They need to do it responsibly. They need to do it in compliance with local laws and with common sense.
It's a complex legal argument which is set down for a 3-day hearing. Jeff Waters, ABC News.